How many times do I get to file an appeal of a denied ERISA case? Generally, you only have one opportunity to appeal your denied benefits or terminated benefits. As a result, you don't want to screw this up. Now, there are two primary considerations you need to consider in deciding whether or not you want to represent yourself in the appeal process or to hire an experienced ERISA disability attorney who knows what they're doing. Now, you may have seen advertisements for books that will assist you in writing a winning appeal letter. And all I can tell you is that Abraham Lincoln once said that a person who represents themselves has a fool for a client. Now, the appeal is the trial of your case. Unlike any other kind of litigation, the ERISA denial or termination appeal is the trial. And once that appeal process is completed, it's very difficult to add to the appeals letter or to the claims file. So you've got to make every argument, submit every piece of evidence, and anticipate the disability carrier plan's rejection of your appeal in drafting and submitting the appeal. Now, a federal judge can only look what's in that disability carrier's file in reviewing the decision to terminate. And that leads me to our second point. If there isn't a second level appeal, basically you are left with the only thing in the toolbox, and that is to file a lawsuit in federal court, because many ERISA disability policies or plans only allow one appeal. So you've got one chance to get it right. Now, if you're fortunate enough to have a second level appeal and you've handled your own and the claim denial is upheld, you get a second bite at the apple. And this is the time you should be hiring an experienced ERISA disability attorney to represent you. You're required under the ERISA rules to exhaust all your administrative remedies before you can file a lawsuit. That means you have to submit that second appeal. Once you've exhausted your administrative remedies, you can then file a lawsuit, but you're stuck with whatever was in that record at the time you filed the last appeal. Not only are you stuck with the record, but the federal judge is stuck with the record. Nothing new can be added, and if you've missed an important element of proof, an argument, something new has developed, you can't raise it at the time you file that lawsuit. It's got to be done right the first time. If you have any questions about your appeal rights, how to find an experienced ERISA disability attorney who can help you file an appeal that's timely, accurate, and complete, and it addresses all the reasons for denial and anticipates the carrier's response or plan's response, call me today at 727-894-3188 for a complimentary consultation. I look forward to helping you get the ERISA disability benefits you deserve. 727-894-3188.